a Victor Penner on the line as well. So I want to see if he's able to talk to us at all. Victor?
Yes, I'm here.
Oh, hi there. Do
Hi.
you mind just introducing yourself to the conversation and
Yeah,
letting
yeah.
us know where you're
I don't
calling
know
from?
if, yeah, I'm from Venezuela. I don't know if I'm a little bit out of place here, but I want to ask a question about a change of status to an F1 visa. Okay, I know it's nothing to do with here, but I know you are immigration lawyers, and I don't know if, yeah. So
Okay, so what's your status right now?
Go for it.
my status right now is a B2 visa, but I want to change to an F1 visa. My status ends in, my visa expires December 16th, so I think I'm a little bit on time to change to the other status. My question is about what happens if before, when I was in Venezuela, they reject an F1 visa. What happened in that case? Can I still apply to a change of status, or I don't know?
Yeah, well, there's a couple things. So yes, you can change status from a visitor visa to an F1 visa. The critical element here is that the school is the one who really has jurisdiction over the entire case. So an immigration lawyer can't provide assistance with the process. You want to make sure you speak to your international student advisor regarding how to go about changing your status from the B2 to the F1, because they have exclusive control over your student records and admissions. What happens at the State Department level in terms of the visa processing overseas doesn't necessarily tie into what's going to happen at the Immigration Service here in the U.S. So for every time a visa is denied overseas, they have to give you some sort of reasoning, right? There has to be a decision. So, whatever that reason was at that time, hopefully, it's a different school or a different program or a different, it's a different situation. So it's hard to give you any sort of specific guidance, but I would say it wouldn't prevent you from filing a change of status and getting approved, for sure.
Did that answer your question, Victor?
Yes, and after I change to an F1, let's say if I stay with the F1 into a couple of years, because I'm also an inventor here, I want to study English first, but let's say that after that I want to apply to a change of status to an O-1. Is that possible? I mean,
yes.
To do a double change of status? Okay, okay.
Yes. Yes. And
Perfect.
just keep in mind, you can always extend your visitor status, too. I mean, I don't know if you're becoming a student because you want to spend more time here or really study the English, but when you're here as a visitor, you can always extend it for another 6 months as long as it's filed timely and you have a good statement and things like that.
Oh, okay, okay. I didn't know that. Thank you very much.
Yeah, sure.
Okay.
So there's a couple of good points that Victor raised here, and we sometimes get questions from, say, particularly actors who have come out here, who are at, say, Lee Strasberg School and what have you, and once they've finished their student visa, they're going to get the OPT, but then going from OPT, which is sort of someone beginning their career, to then creating a case to be an expert a year later, some of them are going to have trouble with that because they're just sort of starting their career. Is there any sort of advice that people can do while they're students or while they're doing all that to sort of beef up their case for when that day comes?
Yeah, sure. Sure. So what I've seen, especially with the actors, as you mentioned in the example, is that so a lot of times they have experience back home before they come here to do a 2-year degree or certificate of training. And so we handle a lot of cases where there are recent graduates who have come from OPT and then transfer over to an O-1. And the whole idea is maximize your opportunities on the OPT. The OPT is short for optional practical training. It is a benefit given to students after they receive a specific degree in that particular field. And it's like a golden ticket. You don't need to be petitioned. You can work for all different types of employers as long as it relates to your studies or your focus of your studies. And at that time, you just want to work. Even if some is unpaid, it still qualifies as OPT work. You just want to build your resume. So if, let's say, you don't have prior experience before coming to the U.S., that's the opportunity to do it. And I know, especially in terms of like those who are in film schools or getting graduate degrees and things like that, some of the work, the thesis films that you create while you're a student can absolutely help an O-1 case, because after they've been produced, they can go off to many, many film festivals for screenings and things like that, and those are considered major achievements for the purposes of the O-1.
Yeah, exactly. And we recommend people trying to do free jobs or cheap jobs, particularly for people with profile or people, like you say, that might be recognizable down, to a assessor. That really is your chance to go out there and do as much as you can.
Yes.
That's
and
great.
Another important element too is that when immigration is looking at experience, they're looking for lead or critical roles. So if you end up working in a production as an actor, for example, and you are an extra in, I don't know, whatever, a Law and Order, something like this, you're an extra, it's not important, right? If you're a lead in a small, off-Broadway production, that's much more important. So you want to make sure that whatever positions you end up getting, if it is unpaid or even for a little amount of money, that the work you're doing can be considered either critical or leading for the purposes of the O-1 case and strengthening that.
And then, any awards that come to that production, whether it's for your role or otherwise, you can use that for your case as well?
Yes, as long as you have a critical role, exactly. So, and of course that could be argued by, another person who is part of the production, the director, the producer, whomever it might be. Yeah.
Now, would you also consider someone who is a head of department to play a leading role? Say, someone who's a gaffer might not play a leading role in a picture, but he's the head of a lighting department, and it might be a big budget movie, or you might have control over 20, 30 people.
Yes. Yes. I mean, definitely. That's a big role.
Yeah, because, we have a candidate in LA who is a visual effects artist. And while she doesn't play a lead role, what she has is a speciality in a certain software and technique that makes her extremely valuable. So although she's, not the lead role, she is playing a critical role in that success. Now,
exactly, and that's the distinction, focusing on critical.
Right. Now, I did get an email from a gentleman from Brazil. His name's Flavio. And he was being advised from a different lawyer about this idea of deal memos and multiple employees. And what he wrote here, in regards to the letters, and I think he's talking about deal memos here, my biggest concern would be having paychecks to confirm work. As Eric said, quote, the only other acceptable evidence to confirm that you have worked according to the visa would be regular payments from companies that gave you the contracts. So that would be my only concern moving forward. I think what he's concerned about is that he's going to have these deal memos to get the visa, and he's not going to have anything to confirm if he has done that work or not.
Right.
What do you say to that?
Yeah, this all goes to how you prepare the O-1 and why you want to find somebody who actually has a lot of experience with O-1s, because there's plenty of immigration lawyers out there, but there's not a lot that actually specialize in O-1s. And for almost all work visas, you have to put in a stated salary for the employee. It's just a matter of law. For the O-1s, you don't. But what ends up happening in practice is a lot of these immigration lawyers who are used to working with other types of temporary work visas, whether it's an H-1B, an L, an E-3, whatever it might be, are used to putting in a stated fee or a stated salary, and it's not required. So my response to that is it's completely irrelevant and it's not necessary unless you're putting in that this person is going to be making X amount of money per year. And if he doesn't make X amount of money per year, then he would be out of status. And so you do need to have those paychecks. But the way we prepare our cases is we never put in a stated salary, A, because it's not required, and B, because, especially in the field of, of entertainment and athletics and everything else, you don't know what you're doing next month, and how would you know what you're going to get paid per year unless you're a regularly full-time employee. So I would say never commit to a specific salary on an O-1. You certainly can make it an hourly fee without dictating how many hours you're working per week or per month or per year. But because it's not a requirement, why put yourself in a box like that and set yourself up for some negative consequences down the line when you just don't need to.
So what could happen if you have a deal memo and you don't end up working for that company, or if they go under, or a deal falls through? That question comes up all the time. If
Right.
we try and explain to clients that the deal memos are just a letter of intent, but, you know, the question comes up, what are the consequences there? Or what can the consequences
Right, and
be?
so it could be, again, I hate to be repetitive, but it really boils down to how the lawyer prepares the case, because we are completely transparent. We always state throughout the case that everything is subject to change. These are tentative plans, tentative itineraries, tentative deal memos. So if you don't have that kind of language in your petition and you have a deal memo, they aren't binding contracts, but certainly the Immigration Service could take a look at it and say, well, you said you were going to be doing this and you didn't because this is how your lawyer presented what you're going to be doing over the course of the next 3 years. You've been out of status if you can't provide us with evidence that you were actually paid as you said you were going to be paid over the course of the last 3 years. So it could have dire consequences in terms of being able to change status, extend status, things like that. But so long as the case is prepared properly, you won't face those issues. It's never my experience, and I fix a lot of poorly prepared cases, and I have to handle. But in terms, it's an easily avoidable situation, to be transparent, because the Immigration Service understands that plans.
Okay, that's cool. So I've just got one or two questions to wrap it up, and then I think we'll sort of close this meeting. I had a question from Vicky from Singapore, who said, if I know someone in the union, can they write an advisory opinion on my behalf? And I guess there's another question there, if there is no union or labour organisation.
All at once to have opinions from the appropriate labor union. And when it comes to major motion picture and television, you need to get not only one advisory opinion from a labor union, but another from a management organization. However, if you work in an industry where there are no, you can certainly use a letter from an expert in lieu of an actual advisory opinion, or a peer letter, something like that. So it's absolutely acceptable so long as you're sure there's no union that applies.
Okay, but the question to, if I know someone in the union, can they write an advisory opinion on their behalf? Is that, what's your response to that?
My response is, I mean, it depends. There's, the union has different departments, right? There's membership, there's O-1s, there's national organization, there's all types of departments within a union. So, I mean, if you have a friend that works in the legal department that handles O-1 advisory